Hello, good afternoon, and welcome to episode number 26 of At Your Service with Haber and Martinez. I am Haber, and that, is Martinez. How you doing, Martinez? I haven't
Good.
seen you since
I got
I
my
haven't
summer
seen you
hair.
since 2021,
I know. And look, I got my summer haircut in the winter.
and I grew out all of the hair that you got rid of. So, waste not, want not.
My head feels lighter. I feel like I should
Well,
get
I don't think you should admit the why of any of that, Ed. But let's talk a little bit about iniquitous mishmashes, because that's what we're going to do today.
You make me earn it, brother, with these 25-cent words.
Well, it's
Are you trying
okay.
to impress us?
I'm a big fan of the thesaurus. So what I was trying to do was figure out what we were going to talk about today, since we had a guest who canceled on us and we didn't really have anything scripted. And so it reminded me of, I was looking for something over the weekend and I couldn't find it. So you know where I went? I went to the drawer that we all have. Everybody's got that mystery drawer with everything that you just throw stuff in the drawer.
You're talking about every drawer in my house.
Okay, well, most people have like one reserved mystery drawer.
Yeah.
I was reminded of that, and I thought to myself, this is kind of like that. It's a hodgepodge. So what we'll do is we'll talk about all sorts of different stuff. You and I were discussing over the weekend a little bit some of the recent high press, high publicity cases in terms of specific aspects of other things that we were discussing, right? So it's not like we were having a discussion about Ghislaine Maxwell, but we were discussing cooperation with the government in terms of whether it's pre or post judgment. And so that's an example of one of the types of things that we'll talk about. But when we talked about those three different topics that we're going to get into today, I don't know that it was enough for us to take up a full hour. Therefore, the hodgepodge or the mishmash or whatever you want to call it, the potpourri, of throwing in some other stuff, since we have received some questions from viewers. At least I have received a couple of questions from viewers, a few of which I promoted on Facebook today, and then there are a few others that we could get into too. So between all of that, I'm pretty sure we could take up an hour with some interesting law talk and probably throw in some good pro tips.
You and I could take up an hour talking about, I don't know, how much it rained today. Let's be honest. But we'd like
Did
to
it rain today?
No, I'm not sure. I think it rained last night, though. But what we'd like to do is make it interesting for you guys, for the viewers that are watching. What Michael and I pride ourselves on are two things. One is obviously not letting politics play anything with anything that we have to talk about here, because we don't think it's what the goal was of the show. And number two is to make it relatable to you guys. I think over the years, Michael's been doing this almost 30. I've been doing this 20. We found that our clients a lot of times, like everybody else, knows what they see on TV and what they think they know what the law is about, and then you read everything on Facebook and you read all these things, that comments that people don't know what the hell they're talking about. And so what we wanted to do was make it relatable for everybody to understand the real nuts and bolts. Like we said, like what the name of the show is, right, Mike? At your service. We're here for you guys, not for us. Michael and I, when we have our conversations, it's really completely different, right? It's like it would be like two master mechanics talking about rebuilding an engine. Most people wouldn't be able to keep up because we don't know what's going on. But
was that a Monty Python reference? And now for something completely different.
Completely different. So we want to make it relatable. And so that's what we're going to be talking. So when we talk about what's her name? Maxwell, Useline. What the hell's her name again?
Yeah, it doesn't matter to me how you pronounce it.
Whatever the hell her name was. We don't want to really discuss the politics of it. Was it good or bad? Did she deserve a life sentence? Does she not deserve a life sentence? Not what we're talking about. Later, if you saw the promo, when we want to compare the Arbery case to the Rittenhouse case, it has nothing to do with any of it, the politics of it or anything. Just the basics of how the law works. All right. So keep that in mind when we do that. And I've been talking way too long. So Mike, get started. Let's start. Which is the first one you want to tackle?
Well, let's start with Ghislaine. And the reason that she came up in our conversation was we were talking about a federal case, and the question revolved around the idea of cooperation. So in federal case, well, first of all, the statistics are not all that far off. If you look at the guilty percentages in federal criminal indictments versus the guilty percentages in state court criminal cases, it's a little bit higher in federal, but they're both, I think it's 94% approximately in state court, 97 in federal. And, with the feds, normally most federal cases result in convictions. That's just a percentages thing. Doesn't mean you can't win. Doesn't mean there aren't defenses. Doesn't mean you can't buy the jury like Willie and Sal. There are different things that can be done. But at the end of the day, you can't
buy the jury. Buying the jury is a crime. But I get what you're trying to say.
It's only a crime if you get caught.
Only if you get caught. But here's the thing. So that one of the things that comes up a lot, right? I've had some clients that read those statistics, and of course your federal prosecutors will agree with what I'm about to say, which most of my clients that read up on those statistics say. They think, and many would think, well, it's because federal prosecutors are so much better. Nah, sorry, wrong answer. Okay. The reason is they don't, and it honestly, to their credit, I think some state attorneys missed the boat. And we'll get to that in a minute, why the state attorneys are different, in my experience. A prosecutor should never bring a case to trial unless they have a good faith base to believe that they can prove it beyond a reasonable doubt. Not that they got a good case, not that they even have 100% locked, solid, probable cause. That's not the prosecutor's job, and it's not their ethical obligation. Their ethical obligation is to only bring a case to trial that they feel they can prove beyond a reasonable doubt. So the feds tend to kick a lot of cases. I remember when I was a state attorney, there were a couple of cases that I took from the feds that the cops brought to me because the feds didn't want it, because in their mind they couldn't prove it beyond a reasonable doubt. Now,
I think there's another component to that, and that is, as in my experience, as a general rule, federal law enforcement is much more complete and diligent, and they have more time and resource than state. State is very reactive. You have a lot of very personal, intimate, spur-of-the-moment crimes that occur in state court. Federal court, it's not uncommon for the FBI or for the DEA or for the ATF to let whatever activity it is they're investigating run rampant for months, sometimes even years, while they continue to document, videotape, send an informant, wire, record, subpoena. And by the time the case actually hits the U.S. Attorney's desk, it's already done.
But here's the reason why, Michael. And I tend to agree with you. But let's be, again, you guys are really getting in. If you're watching, stay with us, because you're getting into the belly of the beast. You're really understanding what is happening here. Michael's right. The federal cases tend to be investigated more thoroughly and better, for lack of a better term. But that's because federal cases tend to be the equivalent of special unit cases in the state, right? When I was a special unit narcotics prosecutor, the cops worked with me. They would call me before they would even make an arrest because we were investigating somebody. Same thing happens in the feds. There's no probable cause arrest in the feds.
The U.S. attorney is almost always involved in absolutely everything before it ever gets filed. So,
whereas in the state cases, you have some cases, actually, to be honest, probably the vast majority, occur in a situation like what Michael said, which doesn't happen in the feds, which is a spur-of-the-moment thing, a domestic violence call, a robbery, a burglary, a DUI. The cops have to run to the scene and do what they got to do on the scene. And since their standard is probable cause only, sometimes they make these arrests and they're good enough. The investigation was good enough to get you to probable cause, but the investigation was not good enough to get you to beyond a reasonable doubt. And since there's no special unit prosecutor involved, the prosecutor in the pits has to deal with it. And when you're in the pits, a lot of times, which brings us back, let me circle back. Let me do
all right, Jen.
A Jen Psaki circle back.
You're wearing an orange shirt, too. If you wear the shirt like a burqa, maybe,
So, circling all the way back, you have young prosecutors who have never done the job of a federal prosecutor or a special unit prosecutor. And to be honest with you, Mike, think about it. How many times have you ever heard a pit prosecutor say, Judge, we need a continuance. We need to continue investigating? Hardly ever. They don't even know, I think, that they can do that, first of all. Secondly, if there's no detective involved because it was a street level arrest, who's going to do the investigation? So there's a whole myriad of reasons why the feds cases are a little bit higher as far as their conviction rate. And there's one last thing, Michael. I don't know if you realize this. Federal judges in the federal court system, they are bound by their guidelines. They're bound by it. And one of the benefits right in the guideline that you are assured of is a lower sentence, a little bit of a lower sentence for pleading guilty. They call it accepting responsibility. So you always get a little bit of a benefit. In state court, it doesn't really matter if you accept your responsibility or not.
Well, I mean, it matters to the individual judge, but you're right. There's no rule like there is in federal court.
Correct. What I was going to say is it matters to some of the judges.
So some of the judges to extrapolate a little bit so the audience understands. In both state and federal court, there's a thing called sentencing guidelines. They're different. They operate differently. They're structured differently, but the concept is the same. And what it is they create a numerical value for a given offender in a given case. And that value will consider extraneous things such as prior criminal history, legal status at the time of the case. In federal court, even more stuff like what they call relevant conduct, role in the offense. There's all sorts of different factors, each of which has a numerical value. And when you do the math at the end of the formula, you come up with a number. And that numeric value tells the judge what sentencing range you are in. In federal court, there are ranges, there are categories, and in state court, it's simply a number value, which gives you a specific number of months that an individual faces in state prison, as opposed to a range as it is in federal. But either way, in both systems, there are ways for the defense or for the state to try and affect that range. So let's just say, for example, in federal court, you may have a range of 18 to 24 months, where the judge could sentence you to 18 to 24 months anywhere within those values without running any risk of appeal, because that's what you score. The defense may go forward and say, look, judge, we want to mitigate this sentence. We want you to come down underneath that 18-month, that low end, and here's why. Or the government may come forward and say, no, judge, we've got some aggravating factors, and we want you to go above that 24-month mark, and here's why.
And those factors that Michael's talking about in federal is specifically enumerated. Your role.
And in state.
Well, but in state, it's not quite as enumerated. Remember, you've got your role, you get X amount of points off, whether you were the main guy.
No, but I'm talking about once you go through all of the scoring, you've got your raw number. Yes. You can still now apply to mitigate or aggravate, depending on which side you're on.
Okay, you're right.
So
then what I was trying to say is, before you get to that part, which is equal with the state, you have what you already said about each
extra stuff
is very specific, and it's already delineated. If you were the main guy in the operation and there were co-conspirators, you're going to get X amount added. But if you were a minimal role, you'll have X amount reduced, and it's an X amount that's set.
I think we'll do a show specifically on the sentencing guidelines where we can really deep dive into this stuff. Yeah. But I don't want to kill too much more time on this. I want to get into why we got into Ghislaine Maxwell. Right. So the reason that we talked about this is in many cases, both state and federal, cooperation with the government by the accused is a way to reduce their ultimate sentence. In federal court, there's two different ways that this happens traditionally. The first is before you are adjudicated, before the case is closed. You go to the government, or the government comes to you and you agree, but one way or another, you and the government reach an agreement that says, I'm going to cooperate with you. It's always done in writing. There's a bajillion conditions in there. But at the end of the day, the gist of it is, if you give the government...
We can't hear you. You got a call. We can't hear you.
I just killed it. Can you hear me now?
I can hear you now. So the last thing we heard is, if you give the government, I'm assuming...
If you give the government enough... I lost video now. I can't see us, but that's okay. If you give the government enough information, then they agree to recommend to the judge a downward departure in terms of your sentencing.
Yes.
Abish?
Yes, and that is...
It's a little disconcerting because I can't...
I got you. I got
Can
you.
you
We'll,
see
we'll do it
me?
like I got you. I'll do it like when we were on the radio. Yes. So, and that is the pre-sentencing. That is before you accept guilt or go to trial or anything. You're trying to mitigate prior to being sentenced and pleading guilty. Okay. But then there's another way in federal you can do it. You want to do it, Mike? Go ahead. Tell us the other
So,
way
well,
in federal
let's
and
go
only
back
in
to
federal.
let's go back to the first one. So, if you do this before you are sentenced, what you're doing is you're gambling. You're going to the craps table with your information, right? You're saying, "Look, government, I'm going to give you X, Y, and Z, and in exchange for that, I expect some preferential treatment." You're never told exactly what you're going to get. There are ranges, and different prosecutors are known for recommending different things, different U.S. attorneys, and different judges are known for agreeing to certain things or not agreeing to certain things. But those things aside, what it's called is a 5K1 departure. Now, you can do the same exact thing after the fact. In other words, you don't go to the government, or the government comes to you and you refuse to cooperate. But in either event, you decide to roll the dice, go to trial, you come back guilty, you're convicted, and prior to sentencing, or within a year of sentencing, you then go back to the government and say, okay, now I'm willing to cooperate. And that's why we started to discuss Ghislaine Maxwell.
Right. And what we started discussing was, again, Michael and I know nothing about this case. I know we got to make it abundantly clear. We do not know the facts of the case. No matter what anybody thinks, what you get on social media is never really all the facts.
Which,
So we don't have to
by the
discuss.
way, is a bunch. Which, by the way, is just an aside, is a bunch of bullshit. I don't understand for the life of me why the federal court system does not allow anybody to videotape, audio tape, publicize, no cameras in the courtroom, no news press in the courtroom.
Is that
They're
is
not
that
allowed to.
is that a rhetorical
Huh?
question? Is that a rhetorical
It is.
question?
I mean, it is
You know
rhetorical.
why.
It's just
You
so
know why.
bizarre.
You know why. You know exactly why. Because they don't want to be scrutinized. Because they're there for life and they don't want to be scrutinized. That's
Well,
exactly
they
why.
should be scrutinized. I mean, that's part of the price that they ought to be
Brother,
required to
you're
pay.
preaching to the choir. However, so getting back to what we were saying, so Michael and I were discussing it, and at first I always thought, this woman must have so much dirt on so many people. Like, why is she not cooperating to get a better sentence? But after the trial, I was thinking about, and this is why I started talking to Mike about it. I think it was a brilliant move on her defense team's part, because if she really does have the blockbuster info that she has, why not roll the dice? Because if she really has info, they want that badly. Michael and I have all done this. They're going to want it. They're going to want it anyway. And now
Are they? But are they? Do they really want it?
I would think so, Mike. I mean, if they don't, again, we don't want to get into the politics of it. So the only reason they wouldn't want this information would be political. Because if you have people, for example, there were some people that were the travel logs show that they went 20 some odd times to this island that everybody in the business and knew was, basically for pedophilia. Why wouldn't you go after a man who did that 27 times? Arguably, I'm sure there were some times where he went to the island, he didn't have sex with a minor, but 26 times, I would think that they'd want that. If they don't, then it's political. There were other people that were on there. Okay.
The other issues that surround that, and I agree with your assessment in terms of strategy, okay? Because in this particular case, you're right. What did she have to lose? It's not like she was going to walk away with her cooperation and get immunity or get a pat on the back and walk down to the courtroom. They were prosecuting her no matter what. And there's always a possibility, again, they may have a 97% conviction rate, but they got a 3% acquittal rate. And she could easily have been one of those 3%, right?
And they did a good job, because whenever there's co-defendants, and especially when this case has had so much media publicity, where everybody assumes what's his name was the mastermind behind it all. When that person is not around or not in a co-defendant trial, it works a lot of times for the defense when you point the finger at the ghost, at the person who's not sitting in there in the trial, because the state can't prosecute that person. So you keep pointing the finger at somebody else, and sometimes it works. So it was a good idea for them to try this.
Well, I happen to agree. I don't think that they had much of a downside here. And now the question is, whether or not the quality and quantity of her information is significant enough to merit what we call a Rule 35, which is that post-adjudication request for a subsequent downward departure. So what's going to happen is, more than likely, she's going to get sentenced. And if she decides to cooperate, she's going to then go back with the government. The two of the defense and the government are going to hold hands and go in front of the judge and say, Judge, we know you gave this woman X, but in light of the cooperation that she provided, in light of the service that she has provided to the United States of America, to the government, we are asking you to resentence her to Y, which would be a lower sentence.
Right.
That's basically what that Rule 35 is.
And again, and getting you into the belly of the beast, Mike just mentioned something. Again, I feel like we're two master mechanics talking about rebuilding an engine. What they want is not just quality of the information, but Mike will tell you what most prosecutors want is bodies. How many bodies? How many more convictions can you get them? So it's not just, hey, I got this one guy who went 26 times to the island. It's, I've got 15 guys or 15 people that I can give you. And one of them went 26 times.
It's indictments and convictions.
Right. That's all they want is the bodies. And she's got to have, Michael, she's got to have so many people.
Well, but you also have to worry about, if you're on her team, you have to worry about her credibility. And, what's the value of her cooperation at this point? What's to stop her from, conjuring up anything? If you're going to defend anyone who she rats, right? I mean, obviously you're going to accuse the source.
She's got good quality stuff, man. She's going to have travel logs. That's number one.
Maybe.
You're going to have all the travel because they have to keep those logs by FAA rules. So you're going to have the travel logs. Plus, I'm sure she's going to have some other things written down. I doubt that the way this operation was.
Whatever it is, as well as I do, that if her testimony resulted in my arrest and you were my defense lawyer, you would be attacking her as having zero credibility.
Well, right. And one of the things that as a prosecutor, you got to keep mindful when I was there is what her sentence will be. She needs to go to prison for many reasons, morally, but strategy-wise. And remember, guys, we don't want to get into the politics. Strategy-wise, just thinking strictly strategy. As a prosecutor, you don't want to give the defense the opportunity to say, well, you were facing 100 years in prison and now you're on probation after you ratted everybody out.
Exactly.
She's going to have to do time, at least half of her sentence. So whatever the judge sentences her to, she's got to do at least half of that so that the defense doesn't have that strength of an argument. But that's just on that one. You want to move forward on the other topics?
Yeah. Well, while we're on that subject, we can roll right into Ahmaud Arbery because that's another case that we were discussing, not regarding the case itself, but in terms of the sentencing, which just came down.
Right.
You had two guys sentenced to life in prison without parole, and one guy sentenced, I think, to life in prison with the possibility of parole. And, the judge didn't have to hammer these people that hard. He had plenty of discretion. He could have gone a long way, but that's what he did. And what I thought was interesting was how quiet and hush-hush his decision was, because it seemed to me he knew he was giving these guys life the minute those guilty verdicts came back. But you never heard it, you never sensed it, and you never knew it until it happened. Right. Which I found interesting.
Well, let me ask you a question because I couldn't remember it. I'm trying to think back. Did they televise those live, the actual trial?
That trial was televised.
Okay, but it
Ghislaine was not, but right. Arbery was.
But it still wasn't as widespread and talked about in the media as much as the Rittenhouse case, was it?
Well, I mean, I think it was. It's just a different type of story, I think it was definitely highly publicized, and it was a very public and contentious case, and it was a horrible, horrible case. Mostly for the Arbery family. I got to tell you, I feel a lot more for them than I do for those three knuckleheads.
Right. And one of the things we discussed so that everybody can understand is when you look at these two cases, Rittenhouse and the Arbery, and you look at them in the sense of the self-defense, whether it's stand your ground or not, but since we're in Florida, we can really elaborate on the stand your ground. A couple of things that my clients, a lot of times, Michael, I'm sure it's happened to you, don't understand is, this and citizens in general. I've heard so many people say, oh, stand your ground gives you a right to chase people down and kill them, hunt them, then kill them. No, it does not. And this is a prime example. Suppose, for sake of argument, let's say Arbery was actually burglarizing that home. He really was. Let's say he was. And these three guys happen up on him and say, "Hey, what are you doing there?" And he's like, "F you, I'm burglarizing this place." Let's say he said it, and said, "You know what? And if you get any closer to me, I'm going to kill all you." And these three guys start running at Arbery, and Arbery takes off running. No matter what he did, doesn't matter if he pulled a knife on them or a gun. Let's say he pulled a gun and said, "Yeah, I'm robbing this place, and if you come near me, I'm going to kill you." And these three guys rush Arbery. Arbery turns around and takes off running. Anything those three guys do from that moment on do not fall under self-defense, because Arbery disengaged and Arbery took off running. And that's why I wanted to point this out to people. No matter what you think about Arbery, these guys are at fault because Arbery took off running. He left and they chased him. Now, at some point, there's some allegations of him turning around and trying to get a shotgun from somebody or something, or a handgun or whatever. But the point is, doesn't matter what happened in that house. He took off running. Now they became the aggressors. Same exact scenario is what happened in Rittenhouse. Forget about what you think. Forget about whether he had a gun or not. Forget about whether he had an AR-15 or not. Think like a lawyer now. We're just trying to get to the nuts and bolts of the law. The minute you see Rittenhouse running, anybody who's chasing him is the aggressor. So when Arbery turned and took off running, those three guys became the aggressors. When one of them got down and put a gun in his face because he caught up to him, Arbery did nothing wrong by turning and trying to defend himself because he couldn't keep running. This is exactly what happened in Rittenhouse. The minute he fell, he's not the aggressor. Now he's in a vulnerable position. So he had every right to turn and try and defend himself. Unfortunately for Arbery, he didn't have an AR-15. If Arbery had an AR-15, he would have been just like Rittenhouse. He would have been found, I truly believe, not guilty by reason of self-defense.
You mean if Arbery had a gun and had shot these three guys instead of these three guys shooting him?
Correct. I'm sorry. I apologize. Correct.
Okay. That makes sense.
It doesn't matter what he did prior to that. He took off running.
Right. Well, the idea is, and we've done a show on Stand Your Ground already, but the idea is that you have to be in reasonable fear of an imminent act of violence.
Imminent, happening right now.
Not a maybe, could happen, might happen, who knows what. No, this has to be very real, very live, and very actual. And it's got to be both subjective and objective, right? So it's not just enough that you think it, but Joe or Jane, average citizen, looking at this, needs to be able to see what you see and say, yeah, you know what, that makes sense.
And much like these guys' defense didn't work because it's true, they were not. That's not a citizen's arrest. You do not have the rights, for lack of a better term, that an officer has in conducting an arrest. That is their job. Their job is to physically apprehend by any means necessary someone who's committed a crime, right?
Well, and why? And why is there a distinction? Because police officers, I mean, let's not talk about individual officers, just generically as a category. They go to the police academy. They are trained in the law. They are put in a training position where they have to do basically an apprenticeship. They have a probationary period of at least 12 months, I believe, with most every department, where they have to ride along with another officer and observe and learn. They're trained. They are supposed to be trained. Doesn't mean that everybody gets it right. Doesn't mean that they're all good at it. I'm just, generalizing.
Yeah, no problem.
The public is not trained to do this.
Right.
That's not your job.
Right. And exactly. And that's the key. There's oversight, and it's not your job. That's their responsibility. That's their job. That's their duty, is to do that.
They are licensed. They are certified.
Citizen's arrest is more like, and again, let's not get into the politics. Maybe I shouldn't even use his name because it's too politically charged. A citizen's arrest is simply this. I did a citizen's arrest. You
were going to go with Zimmerman, weren't you?
Yes, I was.
You can go with Zimmerman. That's okay. Everybody in Florida knows Zimmerman.
It's similar. Yeah, but it's also very politically charged. But it's very similar to what he did. He called and he followed. There's nothing wrong. You can follow people on a public street. Just like they're allowed to be on it, you're allowed to be on it. And they may not like it that you're following them, but when you're on a public street, tough shit. Sorry.
And it may or may not be a good idea.
Right. You're right. It may not be a good idea. Again, let's not get into whether it's a good idea or a bad idea, right? We could argue that Rittenhouse was a dumb idea for him to be there in the first place. We could argue that Arbery was a dumb idea for him to be standing inside of somebody else's home, even if it was a place that was being built. Doesn't mean that he deserved to die. Just like not very smart for you to be walking around a construction site, but nobody deserves to die for that. I lost my train of thought. I was going to say something. Oh, a citizen's arrest. That's what I was saying. You have every right to do what you can legally within the law and within your constitutional rights. That's it, right? If you go to, like, if I see you committing a crime or breaking into somebody's car and I come up to you, let's say I know you're breaking into my friend's car, and I come up, I say, hey, what are you doing? That's my friend's car. Don't go anywhere. I'm calling the cops. And you take off running. I mean, I can run to watch you, but I can't tackle you. I can't pull a gun on you. I can't try and physically restrain you, right? But what if you pull a gun on me? Same scenario. I come up and say, hey, what are you doing in my friend's car? I'm calling the cops on you. Now Michael pulls a gun on me. Now I'm not pulling my gun as a citizen's arrest. Now I'm pulling my gun as self-defense. Okay. These guys with Arbery, they had every right to ask Arbery what he was doing. They had every right to follow Arbery when he took off running. Their mistake, and where they violated the law and obviously escalated and cost them dearly, was getting out of their car with firearms and pointing them at Arbery. That is where the citizen's arrest stopped. That's not a citizen's arrest. So what I think Michael and I wanted to do on this show, and we've got another half hour to go on some other topics, is help you understand that what we go around every day in common sense and morals and our principles and what we believe does not necessarily mean what the law is. And you need to understand the nuances of the law. And for me personally, one of the reasons I don't want to talk about politics on the show is everybody's trying to make everything political, and we can't let that happen. We have to start understanding each other, and we have to start understanding reality. Reality. You may not like the stand your ground law, but it exists, and that's reality. You may not like somebody walking into an abandoned property that's being remodeled or whatever. You may not like it, but being shot over it, that's not the way the law is. That's not reality. So you're just going to have to live with it. You may not like that Kyle Rittenhouse was standing at a riot with an AR-15. You may not like that, but that's the law. And so what I want with this show is to help people understand, guys, when we're talking about these things and we're looking at these things and we're seeing what's coming out in the media, don't let them influence you with their emotional crap. Think about it from the law and learn from it from the law, because one day you may need to use it yourself.
It's funny because just sitting and listening to what you just said, and by the way, I still don't have any videos, so I don't know if anybody can see me or not, but I'm looking at a blank screen.
We can see you, so don't pick your nose.
All right. So it's a little bit disconcerting, but it allows me to listen more. You know that expression, blind men compensate with other senses? So I'm actually paying a little more attention to you than I normally would. That's kind of a compliment there, Martinez.
But it's not saying much.
A backhanded one. So it kind of reminds me in a way of jury selection, because what you were just saying to the folks is really what we do in jury selection. Mm-hmm. And in closing arguments, we hammer that responsibility that a juror has, that incredible responsibility to separate their own personal values and beliefs from the evidence and the law, which Correct. Are really the parameters. Those are what we would call, like, the word escapes me. I always think of that first Star Wars, which was actually the fourth Star Wars, where in the end, Luke's about to blow up the Death Star and he's using the thing and it says, stay on target, stay on target. That's what we're always doing to the jury, right? Stay on target.
Right.
But in reality, what's really ironic is, as defense lawyers, we have to say it, we do say it, but we don't really mean it all the time, right? We want them to exercise common sense. We want them to use their life experience. That's the reason
Well,
that
we
we
do.
put them on the jury in the first place.
But within the framework of follow the law, this is what the law is, and you have to follow that law. So we asked them to use their common sense.
Well, but
for example,
look, it's another pro tip, and it may not be completely legitimate or even entirely ethical, but it's a fact. Okay, that is part of our job, is to sway a jury any way we can within the boundaries. We can't come out and tell them that we want a jury nullification because this charge is so stupid as to defy common sense and to be such a waste of time and resources, and this jury actually sitting in this courtroom for this bullshit, right? We can't say that, but we sure as hell argue it one way or another in certain cases.
Right. And on that point, since again, this is more about the reality of life, and this show is really, and actually what we try to do with all of our shows. You said it was borderline unethical, but not really, Michael. Only if we say what you said. Only if we say we want you to nullify.
You can't say it, but you even steering it there, which we do gracefully and artfully.
I'll tell you why I disagree.
Steering it there.
I'll tell you why I disagree. And I felt like this as a prosecutor, believe it or not. You remember me when I was a prosecutor. It is the defense attorney's job to push the issue, the trial, the case, as hard and far as they can with reasonable doubt. Why? Not because of the guy that we're representing in court that day, right? That guy may be guilty as sin. He may have done it, him or her, whatever. They did it, and they're guilty as sin. But it's for the other ones. It's for the ones that are innocent. It's for the ones that when the cops think they know, and so screw it, we know he's guilty, and they start cutting corners. The prosecutor, oh, bullshit, you know he did it. That's why we push it, so that every prosecutor and cop knows on tomorrow's case, you better get your shit right. Because if you go up against a good attorney, they're going to push the envelope. And if there's even an ounce of reasonable doubt, the guy walks. That's why I always felt defense attorneys should push the envelope.
I think a lot of that is also selfish to us too, right? Because it's not so much for random people that we don't know. It's also for us, because we develop reputations. Everybody develops a reputation, whether you want to or not.
Right.
And so, the question is, do you develop, look, you and I both know, although we would never name, at least not publicly, but we both know plenty of lawyers that we would use the word hack, right? These are people that we know are going to sign a case. They are never going to lift a finger to do any kind of proactive investigation or challenge anything. They're in it to get diversion or to get a plea and earn a quick fee and get on to the next case. That's it. A great example of where that happens is with DUI cases. There are so many DUI lawyers out there that sign DUI cases on the cheap, knowing that they're going to plea it out. Either they're going to get diversion and they're going to convince the client to take it without doing any legwork, or the client's going to be ineligible for diversion, and then they're going to sell a non-jail plea because they're going to scare the client into not wanting to go to trial, and being diversion ineligible, the only other resolution is a plea. Right. And so it's real easy to charge $399 or $699 to do that, because what are you really doing?
Nothing really. Really. I always tell people
there's no work.
I always tell my clients, listen, if you can't afford a good lawyer, stay with the public defender. They may be overworked, but at least they work. At least they care. And they will, not most of them, obviously, will fight for you. Now, here's the reality that people don't know. You want to get into the belly of the beast? Let me tell you why that is a problem, and why even as a defense attorney, as a prosecutor, I wanted defense attorneys to fight and push the envelope for reasonable doubt. Prosecutors have twice as many cases as a public defender. You think a public defender is overburdened? Prosecutors have anywhere from 150 on the low end to 400 cases. So what ends up happening after you've been with the prosecutor's office? It takes everybody a little bit longer than others, but rather quickly you start learning that some guys just don't go to trial. Some guys don't push. Some guys don't care. You give the offer and they'll sell it for you. Now, what does that have to do with the prosecutor? It's human nature. It's not unethical. I've never known any prosecutor to do anything bad on purpose. However, Michael, if I got to prep 50 cases for trial on Monday, and I know that out of those 50, I've got 20 or 30 defense lawyers that I know will never go to trial and are never going to push the case, I'm not going to focus on that case as a prosecutor. I'm going to do the quick review. I'm going to do the best I can, and I'm going to make the offer. But if there's anything missing, anything I didn't catch as a prosecutor, I'm not going to change my offer to make it a better offer, because I got to do 20 other cases or 30 other cases where I know the friggin' defense lawyer is actually going to work, where I know I might actually be in trial on this shit. So I got to focus on those. So I don't have time to focus on these. And what ends up happening, because you hired a shitty lawyer who didn't charge enough to work, there's something in your case that, had it been brought to the state attorney's attention, he might have given you a better offer, or who knows, he might have actually dismissed the whole damn thing. Happened to me on a case, told you recently, remember the one I called you about, where the prosecutor was sick, but I'm looking at the affidavit, I'm looking at the arrest affidavit, and they stopped my client for committing a traffic infraction in the parking lot, which you can. So you guys understand, if there's a stop sign in a parking lot and you take that stop sign, a cop can give you a ticket. Okay, they don't need permission from the mall. But because she was overburdened,
and another driver can get out of their car and throw you a beating too.
Correct. So since they're overburdened and they're, the prosecutors are working hard, she was sick. I had emailed her, but she never really noticed. So I had to go to her division chief. But this is why my client pays me what he pays. I went like 2 or 3 extra times to get a hold of somebody so I could say, can you please look at this? He puts in the arrest affidavit that he stopped my client for committing a traffic infraction, but he never says what the traffic infraction is, and he never gave him a citation. So that's a 50-50. The state could argue, well, I'll bring him in, file your motion, do a hearing, bring him in, and now he's going to testify in open court, and the judge may say, good enough for me, let's go forward to trial, I'm not dismissing it. Some judges might say, nope, sorry, 4 corners of the A form, tough shit. If you didn't put it in there and there's no citation, I'm dismissing it. So it's incumbent upon guys like Michael and I to bring it up. Brought it up to the division chief. 2 weeks later, she didn't even call me. 2 weeks later, they dismissed the whole damn thing. Right? My client did commit a traffic infraction. My client did have cocaine and marijuana in his car when he got stopped. However, that cop needs to learn, because tomorrow he does it to somebody who's innocent. Do it. Write it down. Do it the right way. So this is why you got to make sure, if you have the money and you want to fight your case, you got to hire a lawyer who's going to fight, because it'll affect the prosecutor when he sees who your lawyer is.
Pro tip.
It'll affect the prosecutor. Trust me.
Let's hit these questions that I've got that were submitted to me. One of them was. The first one is, what is a Parker case and why can't I get a bond? What is a Parker case and why can't I get a bond?
You told me, I saw that earlier, and I'm going to confess, I did not know that what we're about to talk about is called a Parker case. Did not know that.
So you're completely familiar with the idea, you just didn't know the name.
Correct.
So a Parker case refers to a situation where somebody was arrested and they're out on bond. That case is pending. During the course of that case, while that case is still alive and you are out on bond, you get arrested for some unrelated new offense that has nothing to do with this case.
Correct.
You are entitled, unless it's a non-bondable offense, the new charge, you're entitled to a bond on that new case. In Florida, there's a constitutional right to bond, unless you fit into certain categories. And again, we did a show on bond. You can go back and watch it if you'd like to know a little more about that. But what Parker says is, even though you're entitled to a bond on that new second subsequent arrest, the original judge on your original pending case can revoke your first bond and incarcerate you without bond because of that new arrest, because it's a violation of the condition of bond. And the Supreme Court case that authorized the original first case judge to do that was a case called Parker. And so that's where we come up with the concept of a Parker case. And so the reason...
Mike, can you still see us or not?
I can't see anything.
Okay, so
I've got a blank screen.
All right, I'm going to treat you like we're on radio, so you know I'm still here. So you were saying, so the thing is, this has happened since the day I started. Actually, 1 week, I think it was 1 week out of training at the state attorney's office, I made a Parker argument, which I guess is what's called now. not knowing that it was called Parker. I mean, everybody knows. I tell my clients, for example, again, pro tip, can tell you the truth, right, Mike? I'm about to share something that we all know. The judge has every right by law to do what Michael just told you. Okay? A couple of things you need to know. In almost every county in Florida, every county I've ever been in, Michael, let me know if you've been in one differently. If you've got an open case in front of Judge, let's say Haber, you got an open case right now in front of Judge Haber, and you get arrested on a new case, typically, if you had no other cases and no probation, you get blind filed into any judge. But since you have a case in front of Judge Haber, your new case goes straight to Judge Haber. So guess who's going to find out that you were out on bond and you got rearrested for something else?
It's a gimme for the state. It's a gimme.
And he's going to be pissed just for the fact you got rearrested, but then he's going to want to look at the facts. And if the facts are something that is not in your favor, even if it is sometimes, the reality is that because the judge can, 90% of the times, in my estimation, they will take you in and
of
hold
course
you
it
no
depends. Of course, it depends on the nature of the original case, the nature of the subsequent case, whether there's any mitigation, or their medical situations, or their familial situations.
But again, Mike, pro tip.
There's always argument to be made.
But that's
I want to. Here's what I want to. Here's what I want to say.
By a good lawyer, not a hack. You got to hire a lawyer who knows how to deal with this situation.
Well,
because I'm telling you, 90% of the time, they're going to want to take you in.
So here's what I want to say about that. I'm actually going to read something. So, one of the things that you can use as kind of an objective criterion for attorneys when you evaluate them is how much information they give you. In my standard retainer agreement, every client who hires me gets this language on this particular topic. It's a paragraph in my retainer agreement where I basically say to the individual that if they violate any condition of their bond, then the bond can be forfeit by the court. And if they wind up having their bond forfeit by the court, they face new additional charges. Whatever the case may be, there's additional expense. So I try to explain to the client up front, this is one of the pitfalls. You need to walk on eggshells when you have a pending criminal case, because anybody can get arrested wrongly, falsely, being in the wrong place at the wrong time. The 3 W's that I like to do: wrong place, wrong time, wrong cop. You don't even have to do anything wrong for those 3 things to occur, and you wind up arrested. If you are out on bond at that time, well, the foreseeable consequence is that bond is going to be revoked, and you will now have severely complicated that original case, much less picking up a brand new one. You've now changed the attitude of the judge. You've changed the attitude of the prosecutor. The dynamic of the case is different. Instead of dealing with one charge, we're now dealing with 2 separate cases with potential consecutive sentences. It's a problem. It's a problem for everybody, but the biggest person that it's a problem from is you.
That's right. And another pro tip. When you get stopped by a cop and you're either on probation or you have an open case, especially in the same county, that cop's going to know. The minute he gets your license, the minute he runs your name, he or she, they're going to know. They're going to know, Michael. How are they going to know? They're going to know. That's from TikTok. They're going to know, right? And why do I say that to you? Because now is not the time to piss that cop off, right? Now is the time to be really, really humble, because they could easily arrest you on probable cause. Remember, we just talked about it. Probable cause is much lower standard. So you piss that cop off, he's definitely going to arrest you. Why? Because he's going to know, sorry, pardon my French, fuck you. So when you sit there telling a cop, fuck you, I know my rights, you pigs, go fuck yourself, he's going to get the ultimate fuck you when he arrests you. Because I got news for you. Suppose he arrests you, Michael. So how many times has this happened to you? My client got arrested, he's out on bond, right? Our client get arrested, he's out on bond. He gets arrested for the new case. The state attorney doesn't even file the charges. They no action, the whole damn thing. And the judge still takes him in and holds him in. And that happened because the judge can. The judge does not have to release you just because the state dropped the charges.
in a way, it's very much like a probation violation. Even if your new substantive case that you picked up while you're on probation gets dumped, you can still be violated for just being arrested.
Correct.
And in the meantime, while all that's being worked out, you could be held without bond. So
Right.
the point is, if you have you should never have a Parker case. You should never want to have a Parker case. You should never get arrested. But if you do get arrested, walk on eggshells and make sure you don't get arrested while you are have that case pending. Let's get to the next one. I'm 17. I live in Florida. Can my 18-year-old boyfriend be charged if I get pregnant? So there's several things to unpack here, but let me start with this. First off, in the state of Florida, 16 and 17-year-olds can consent to sexual activity with somebody else, provided they are also no younger than 16 and no older than 23. If you're 18 or over, you can have sex with anybody from 16 to 110. But
Right.
if you are under 18, the window is 16 to 23, and the key is consensual. So if you GHB somebody, if you slip them a Mickey and then fool around with them, that's not consensual.
Did you seriously just say slip them a Mickey?
Yeah,
Did you
that's what it used
seriously
to be
use that
called. What is there a
reference?
new term for that?
Yeah, pretty much since like the last 40 years. But okay, go ahead.
What's the new term?
I don't know. I don't slip
What's the
people
new term?
Mickeys.
I mean, I listen
No,
to
no,
music.
don't use-
I listen to music from the 70s, 60s,
I don't-
70s, and 80s too.
I don't use roofies or GHB or any of that stuff, so I'm not sure what the term is, but I'm sure Mickey.
So,
was
well,
not
my
one of
point
them.
is, look, let's say that you're in high school, you're of age. I mean, it wouldn't even matter because the same principle applies to even adults.
Correct.
Just not in that statutory type of scheme. But the point is, if you take advantage of somebody who's intoxicated, whether you did it to them or not, they could do it to themselves. Somebody
That's
could
true.
just drink too much and pass out. Or if somebody is incapacitated for another reason, for example, mental illness or mental incapacity, anybody that you take advantage of in that way, age is only one of those disqualifiers, becomes a crime. But if it is consensual and if you fall within those guidelines, stay on target, Luke, stay on target. As long as you're
Right.
no younger than 16 and you're no older than 23, there is no crime. So to answer
that's
this
called
question,
the Romeo. That's called the Romeo and Juliet.
no, that's not Romeo and Juliet. That is not Romeo and Juliet. Hang on. That's the second qualification.
Okay.
That is, there is no crime, period.
I got you. I see what you're saying. Right.
Romeo and Juliet is a way to avoid sex offender stigmata after you've been convicted if you fall within another
Right.
range. So, if you meet the requirements under the statute where you can't be any more than 3 or 4 years distance from the individual victim in the case, who can be no older than X, and if you meet all of the bullet points, then what happens is Romeo and Juliet gives you an escape. It doesn't excuse the crime. It doesn't eliminate or prohibit a conviction.
And it's just consensual.
It just affects your requirement, if it's granted, to register as a sex offender. So you still have the record, you just don't have the continuing requirement.
And another
But the
thing.
third thing.
Okay, I'm sorry. I didn't know you had a third thing. Go ahead.
That's okay. The third thing about this particular question is, she asks, can my boyfriend be charged if I get pregnant? And the answer to that is absolutely not. Pregnancy is not part of the equation here. It's unconsensual sexual activity or sexual activity with someone who is incapable of providing consent. So if those things don't occur, if you are within the age parameters and somebody gets pregnant, there's no crime there. There may be a crime against nature. There may be an unethical thing. There's certainly going to be issues revolving teenage pregnancy and lifestyle and, fairness to the baby and this and that, but it is not a criminal act.
Correct.
I'm sorry, Ed, I know you wanted to say something else.
I just wanted to say something because it comes up so often that I don't think people understand as far as sexual battery with a minor, someone who's 16, 17 years old, let's say 16, or even 15. there is no, it is what we call in the law a strict liability crime. The girl, let's say the girl's 15 years old, but she looks like she's 22, and you meet her at a club that is 21 and over only, and they
And
let
she
her
even
in.
shows you an ID and a birth certificate.
She's got a fake ID, she's got a birth certificate, and she's got 9 bishops and nuns standing
Right,
behind her,
16 character witnesses.
swearing that she's 19 years old. All of that. She sends you in a text. She wrote it on your Facebook page. Her thing on Facebook says she's 19. Does not matter.
Too bad, so sad.
If she looks, this is the best advice I give people. If she looks anything younger than 30, you better get to know her real well.
And her family.
Meet her family, make sure that she's not, like not her friends, because she could be in high school and all her little high school friends. But I mean, again, if she's 15 and she looks like she's 20, but all her friends look like they're 15, that should be a red flag to you. You've got to make sure there's no way around it.
You know the old saying, 15 will get you 20.
And there's no way around it. I'm telling you. I think I've said this many, many, many times before, but this goes to your issue. This is, again, another pro tip. What is it? 2 times up? How is it that you say it?
Up X2. Hashtag up X2.
Up X2. And I know I've said this story before where I had a client who was who had sex with a 15-year-old, but she looked very, very mature for her age. I mean, honestly, she looked like she was about 25. And he didn't know. And he got pulled in by the cops. The cops wanted to talk to him about her. And he said, all right, I'll come in and talk to you. And they'd just like not even been dating. They were like kind of like they do today, the whole Tinder thing, even though he hadn't met her on Tinder. But whatever. Point is, he went to see the cops. And this is a prime example on why what I'm telling you is strict liability and why you never talk. The arrest affidavit said that they told my client, did you know she was 15 or something like that? And that my client said, yeah, she's 15. Okay. Affirmative statement.
We talked about this is the one where we did the comparison with the sack of suds in My Cousin Vinny. I shot the clerk.
Right. But I just want to say again, as a perfect example, look what happened to my client. So when the cops asked him, 15, he said that his reaction was, she's 15. He didn't know, but they didn't write that. They wrote it like it was an affirmative statement. So now it looked like he confessed.
Right, an admission, a confession.
And it doesn't matter because his first mistake was this. The first question the cop asked when he walked in, guess what it was, Michael?
Are you willing to speak with me without a lawyer?
No, well, there's 3. You want to speak without a lawyer? He said, yes. Do you know so-and-so, the girl? Yes. Did you have sex with her? Yes. Done.
Right, so it should have been 3 no's and out. Listen, we got 2 minutes left and 2 more questions. So let's see if we can bang these out. How do I inquire with the court about the status of a pro se motion to modify probation that I filed 35 days ago? So here's the first answer. Don't file pro se motions, and you won't have to ask lawyers how to practice law.
I think that should be the answer. Move. Next.
Yeah,
that should be the answer.
It really is that simple.
If you didn't know what you're doing, it's like trying to rebuild again, since today's theme, apparently my analogies are all with cars.
Mechanics.
Yeah, it's like trying to rebuild your own engine. And then when you got the engine in pieces in the garage, you call a mechanic and say, hey, how do I put this thing back together? You should have called me in the first place.
So here's the last one. I actually had one more I was hoping to get into, but
we can go time today.
So here's the last one. Do we need a public defender or a paid attorney for this case? And the answer for that is really simple. It is a matter of whether or not you are entitled to a public defender. You don't have a choice. You don't get to pick and choose. Either you can afford to hire a lawyer, in which case you must, or you're indigent and you cannot afford to hire a lawyer, in which case you're entitled to the services of the public defender. It's not a do we need or should I hire. Either you can, in which case you are obligated to, or you can't, in which case obviously you do not have to.
And if the question is, Michael, should I get a public defender if I'm entitled to it, or hire one if I can afford it, or should I do it on my own? What is it that we always say as lawyers? A lawyer who represents himself has a fool for an idiot. I mean, for a client. Has a fool for a client.
That's
an idiot.
It's Abe Lincoln's quote, not ours.
Well, whatever.
Let me just touch on this last thing real quick, because this is a kind of recent development, and it involves a question of whether or not you need to give the police your access code, your password to your cell phone. And this is now a really hot subject because cops are asking for passwords and people are saying no, and then they're getting arrested. And police are getting search warrants. So in this particular case, a search warrant was actually issued by a judge. And here's the exact language from the warrant. Quote, law enforcement personnel are authorized to direct and compel any person who is reasonably believed by law enforcement to contain knowledge of a password to the device named in this search warrant to provide such password in order to allow access to search the device pursuant to this search warrant. So basically what they're saying is, in this case, it's a cell phone. The judge basically wrote an order authorizing the police to compel the owner of the phone to give them the passcode so that they can search for incriminating evidence, which they otherwise can't get without his assistance. Is that insane?
That's insane. That has to be appealed. And let me give you an analogy.
So, well, hang on. Before you give an analogy, let me tell you what the law is. So there are several district courts of appeal here in the state of Florida, and they take up larger chunks than just the trial courts. So the first district court of appeal has actually handled this question, and they've said, no, this is absurd. The second district court of appeal has addressed this issue, and they've said, yes, the judge can do that. And so if you refuse to give the password, you can actually be incarcerated and held in contempt of court while they're holding your phone and trying to find other incriminating evidence. The fourth and the fifth DCA have all said no. And the third DCA apparently has not ruled on it. The case is scheduled to go in front of the Florida Supreme Court. I
would suspect that the Florida Supreme Court has got to say, no, a judge cannot do that. And I'll give you a very simple analogy. It happens all the time. The cops get a search warrant to search my house. I don't have to open the door. Now, once they got a search warrant, you might as well open it, because with that warrant, they have a right to kick it in. So you have a right to get into my phone with a search warrant, figure it out, get a hacker. I don't know.
Exactly.
I don't have to give you the
But that's not right. But the question is whether or not the Florida Supreme Court will agree with that. I happen to agree with you. I think it's absurd. I don't think that I think it's a violation of your Fifth Amendment right. You do not have to become a witness against yourself.
Right.
You can't obstruct the government from doing their own diligence. They can, try to crack that phone 6 ways from Sunday if they lawfully have it in their possession and they have a warrant.
If the cops get a warrant, you can't take your phone in their presence, or even not in their presence. You can't take their phone and intentionally destroy it, throw it in a lake, something of that nature.
No.
That's obstruction of justice.
Well, it's also tampering with evidence, which is a crime.
Right. But nothing says that I have to open the door of my home. You get a warrant to search my house. I mean, if I don't feel like opening it, fuck you, break it down. Maybe I don't like that door. Maybe I wanted to get a different door and I didn't want to hire guys to do the demolition. I mean, I don't have to give you the keys to my house. So I can't imagine the Florida Supreme Court finding that that's okay. Can't.
Well, we'll check in and let you guys know when the Florida Supreme Court gives us an answer.
And I'm sure Michael will be glad to say I was wrong.
Nah, I think you're right. I'm with you on this one. We're both on the same page. So we've gone a few minutes over. I want to apologize for that, but thank everybody for their patience. This has been an interesting show for me because I have literally been staring at a blank screen since about 20 minutes in. So I hope that I haven't said or done anything stupid.
Not more than you. Not any more than usual. Listen, not anymore.
Yeah, usually I'm able to see the stupid before it happens, but this time I can't. So who knows? Anyhow, it's been a pleasure being here. I'm glad that we're able to, even though it was a week late, start the year off with episode 26. Next week we'll see you on the 17th. I don't know what we'll be talking about, but we'll figure something out. We'll promo it. Are you going to be able to do a show on your birthday?
Yeah,
Martinez,
sure.
Or are you going to want to take the day off?
But I do expect to see you at least with like a cupcake or something.
Oh, I definitely will. I will eat something delicious in your honor.
That's all I want.
Hey, who knows? Maybe we'll actually do an appearance at the studio.
Maybe we'll do it together. I'll bring Bo. You haven't seen Bo in forever. Who knows? You can say hi to Bo.
Delicious.
All right, guys.
Thank you very much for tuning in. Ed, always good to see you. We'll see you all next week, and we'll look forward to being back at your service. Take care, y'all. Have a great day.